Hello, this is the third in a series of webcasts looking at pension law technical bites, looking at the new crimes, fines and penalties under the Pension Schemes Act 2021. This one dealing with the reasonable excuse defence, probably the most difficult bit of the new crimes. I'm David Pollard, I'm a pensions lawyer. I'm a barrister at Wilberforce Chambers in Lincoln's Inn, and today is the 20th of April 2021. So I've already discussed in the two previous webinars an overview of crime, fines and penalties, looking at what's going on. This, in particular, an overview and the elements of crime. This one's looking at reasonable excuse, focusing on the new crimes. These are webcasts intended for professional advisors, so it's being suitably cautious about reliance and things like that on it. This is new legislation. It's not yet in force. We haven't got a track record. We haven't got any history either of what the regulator does or of how the courts react. Much is going to depend on the precise factual situation in any particular case. And the risk of the regulator acting is probably going to depend on its policy for prosecution and things like that. Now, the whole aim of these new offences, the criminal offences, is to give new teeth to the pensions regulator, new dentures, as the current pensions minister call it. And that's going to mean that transactions or doing things that involve either a pension scheme or an employer, or could affect a pension scheme or an employer or their benefits, there is an element of standing back and thinking, well, am I doing something that adversely affects those? Could it be material? Am I doing it intentionally? Do I know I'm doing it? Is there a reasonable excuse? That's what this webinar is going to be about. So the three new main crimes, the first one's failing to pay a contribution notice without reasonable excuse. Well, hopefully if you've got a contribution notice, you'll have been notified and fairly far down the process. That's going to be fairly obvious. But the two new main crimes that are more diffuse, wider: avoidance of employer debt and conduct risking accrued scheme benefits. That's a broad overview of what they were. And in both cases, there's a defense, or it doesn't apply if the person did not have a reasonable excuse for doing the act or failing to do the relevant act. And there are equivalent financial penalties. That's up to £1 million levied by the regulator as a penalty. And that's slightly differently worded. It was not reasonable for the person to act or fail to act, but it's a similar sort of process. Now, these are widely framed crimes, as I've said in the previous ones, not just employers or trustees or associates, not limited to willful or reckless acts. And we haven't got a track record. We don't actually know how these are going to be used. So there are going to be three elements to any particular crime: causation. Did you do the act that had the relevant effect or failed to act? Was there intent or knowledge or purpose? What's that mental element? Did you know what you were doing? Did you intend it? Was it purpose? That sort of thing. And the third element is no reasonable excuse for the criminal, not reasonable for the financial penalty. So that's the key defense. There is no other safe harbor provision. There's no getting the consent of the regulator, the consent of the court doesn't get you outside this offence. So reasonable excuse is scattered already all over the Pensions Act 2004, 34 times, my search did, and it's in quite a lot of criminal statutes in other areas. The Terrorism Act 2000, the Public Order Act 1986. So we can look at those acts and the case law on that and say, well, probably a similar approach is going to be followed in relation to the Pensions Act, although not necessarily. So there's a sort of slight element of caution in that. And there are being Court of Appeal decisions, particularly on the Terrorism Act, which has got another very wide criminal offence of possessing articles likely to be useful to a terrorist. And the Court of Appeal back in the late 2000s said, well, you might have not had you need a reasonable excuse, but actually doing something because you have a lawful excuse is all right. You need a purpose or intent to be unlawful. That was disapproved by the House of Lords in 2009 in the G case. That gives no scope to this use of the word reasonable in the Terrorism Act. That's probably going to be helpful, probably going to be followed, would be my guess, my anticipation in relation to the Pensions Act. So the onus on showing no reasonable excuse is going to be with the prosecutor. It's normally going to be the pensions regulator. And you can contrast that with some other provisions. Other sections in the Pensions Act talked about failed to take all such steps as are reasonable. And sometimes the onus is on the defendant to show that they had a reasonable excuse. But the government in the parliamentary debates confirmed it thought it was with the regulator to show whether or not there was a reasonable excuse. And in the G case in the House of Lords, going back to this terrorism one, they said it's going to be very much dependent on the relevant offence. So failing to give a urine sample without a reasonable excuse, that sort of ties in, because the actual offence is tied in, that ties in where reasonableness comes. And they're going to be many or various. The one I like is a male stripper dressed as a police officer, that I'm quoting from the House of Lords here, who was waiting for his performance to begin, was held to have a reasonable excuse for carrying a truncheon in a public place. That was approved by the House of Lords, Frame and Kennedy. So what is a reasonable excuse is going to be determined in the light of the particular facts and circumstances, said the House of Lords. So it's going to be a jury decision. It's a question of fact guided by the judge in the Crown Court, or by magistrates in the Magistrates' Court. So you're going to have to look at all the facts. Presumably, this is my gloss on it, having a reasonable excuse looks at the position of the relevant defendant at the relevant time of the act or the failure to act, looks at what is reasonable for that defendant from the defendant's perspective, not from the perspective of the pension scheme. Did you have a reasonable excuse? Nothing to do with the pension scheme or the employer, it's to do with the particular defendant. So if they're a third party not connected or associated, it might be more reasonable to do things that are acting in your own interest or where there's no other separate duty. So three main structures for the risks of something happening is the regulator decides to investigate, the first stage, lots of information powers. Second stage, regulator decides to prosecute or institute a financial penalty. And third stage is the court convicts, or the determination panel issues a financial penalty. And the significant costs can be incurred at all three stages. But for the first stage, whether the regulator is likely to act, the regulator is issuing guidance on its prosecution policy. There's draft guidance that's come out for consultation. Consultation ends in a couple of days, and that's pretty helpful, but it is focusing on the regulator's policy. So in practice, if you're not being terribly nasty, sort of what the regulator keeps saying, you're not being outrageous, these aren't words used in the legislation, A, they might be less likely to bring a prosecution, and B, hopefully you wouldn't get convicted. So if you took professional advice, perhaps consulted the regulator or told the regulator, consulted pension trustees, or if you're not linked so much, you're acting your own interests, and it wasn't your primary aim to do nasty things to the pension scheme or to the employer, those are perhaps reducing the risks of the regulator acting, or indeed of an ultimate conviction. So there's lots of talks about outrageous in there. Problem with the guidance is it is only guidance. The regulator could change its mind. It's not going to be binding on the regulator. And to a degree, there's perhaps a risk of sort of public opprobrium coming to someone who does something, and the regulator will come perhaps under some pressure to exercise its powers. So in practice, if the scheme isn't insolvent, if it's not very underfunded, the employer's not in difficulties, regulator thinks that contribution notices or financial support directions are unlikely to help, or the target is not associated, or the person targeted by the regulator has been involved in causing, those are all factors that probably would increase the risk of a claim. There are slides which give some more of the detail. They're on the link above or the link below, depending on where it is. And there are some tables at the end of the slides talking about crimes and contrasting contribution notices and financial penalties and the new crimes. I hope that's been helpful. If you have any thoughts or queries or issues, please don't hesitate to contact me or indeed Wilberforce Chambers, and I hope you've enjoyed that so far.